Okay, we need to talk about what assets to put in a living trust. This is especially important because yes, you need to know what assets should go into a trust, but you also need to know what assets should not go into a living trust. That's what we're going to take a look at. In this video, you'll learn how to handle certain assets. You'll see how different assets receive different treatment. You'll find out which assets should go into a trust, and you'll find which assets should not go into a trust. And I'm going to show you how to handle your assets. Now, one of the things we absolutely have to understand is that in order for a trust to have any benefit whatsoever and to assist you in any way with your estate plan, you have to fund that trust. Now, what I mean by funding that trust doesn't mean that you subsidize it. It doesn't mean that you capitalize it. It doesn't mean that you put money into it. Basically, it means you transfer assets into it. Now, those assets may be money, but it may also be things such as real estate. It could be personal effects. It could be your furnishings. It could be jewelry. It could be firearms. Whatever it may be, you have to have those assets transferred into that trust in order for that trust to give you any benefit whatsoever. Again, that's called funding a trust. So the type of trust we're talking about is a fully funded revocable living trust. By fully funded means all your assets are transferred in there, except for those assets that are not transferred in there. I know that may sound confusing, but there are certain assets that you do not want to put into your trust. We need to take a look at what those assets are. But before we do that, we need to take a look at the process of transferring assets into the trust. You know, whenever I work with clients, one of the things that I take them through is the process of identifying who they want to leave their assets to, how they want to leave those assets, and how those assets will be managed. But I also have to make sure that we provide instructions and basically the documentation to transfer the assets into that trust, because if it's not transferred in, it's all for naught. We may draft up an incredible trust agreement, but if it doesn't have anything to govern, it's not going to give us any benefit. So it's only for those assets that have been transferred into it. So that process is typically with documentation. Now, for certain assets, you may require added legal documentation, such as maybe a warranty deed or a quitclaim deed for real property. And by real property, I don't mean as opposed to unreal property. I mean real property like real estate, as opposed to personal property. You know, for real property, you've got to make sure that you file a deed transferring title out of your personal name into your name as trustee of the revocable living trust, and that is facilitated through the county recorder's office. You know, in every county, they're going to have an office that essentially records real estate transactions. While this is not necessarily a transaction, it is a retitling of the asset. And that retitling needs to be recorded to make sure it takes effect. You'll fill out either a warranty deed or a quitclaim deed in most instances, depending upon where you are. Now, the reason that we're not as concerned about a warranty deed, some states will require the warranty deed, but typically a warranty deed is saying I am warranting, I am guaranteeing essentially that I do have ownership to this property. Now, if I was purchasing a property from somebody else, maybe a third party, then I definitely want to make sure that I have a guarantee that they actually have ownership of that. When we're transferring property essentially from ourselves to ourselves, meaning from our personal name into the name of our trust, we're not as concerned about that because we're just saying, hey, I in my personal name am quitting my claim, hence the name quitclaim. A lot of times people think it's quick claim, partly because it's so quick. And it is quick, but it's a quit claim. I'm saying I'm quitting my claim to this property and transferring it over to you so you can now claim this property. That's how it all works. That's how you transfer real estate into the trust, but we've also got to take a look at how to transfer other assets into the trust. For personal property, typically we do what's called an assignment of personal property. It's essentially a blanket assignment that says, I hereby transfer, convey, assign all rights to my personal assets out of my personal name into the name of the trust. This way you don't have to keep an exhaustive, detailed inventory of assets that's constantly in need of updating and revision anytime you acquire an asset, you relinquish an asset. No, this way it just basically says, I'm leaving everything, I'm assigning that through this assignment of personal property into the name of my living trust. When we're talking about real property, though, the real estate that we may own, one of the things we've got to understand is that there is a different process if we're transferring our personal residence versus if we're transferring our rental properties. There are going to be additional steps involved if we're talking about our rental properties than there would be if we're talking about just our personal residence. So with our personal residence, we do what I just mentioned as far as filing that quitclaim deed, taking it to the county recorder's office, getting that recorded, paying the recording fee, which once again is going to be a nominal fee, but basically then you're done. When it comes to rental property, if we just transfer it, we do that same process that we just did for our personal residence, we don't have any liability protection. Well, obviously, one of the things that if you watch my videos, you'll learn that we always focus on so many different topics, which is a great reason to watch all the videos that we produce. And that's because we have asset protection, estate planning, and tax reduction. 3 areas that you always have to focus on. Well, in this particular instance, because we're talking about rental properties, we need asset protection. We need tax reduction. As a result, we're typically going to utilize limited liability companies or LLCs to accomplish this. Well, if you have property that you're transferring out of your personal name into the name of an LLC, you're going to go through that same process of going to the county recorder's office. But once that property is in the name of the LLC, that's great for asset protection. But what about estate planning? That's our primary objective with a trust, so we've got to make sure that we have that LLC transferred into that trust. For that, we utilize what we call an assignment of limited liability company interest. This is basically a document that it's an internal document that you utilize that I typically tell people to keep 2 copies of this. One with their estate planning records, but then number 2, keep it with your limited liability company records, which you better be keeping in order to make sure that you get the asset protection. But this is important documentation, and it's important things that you need to know about. Most people don't know this, and as a result, they make mistakes. They were unintended mistakes, but they're mistakes nonetheless. That's why we put this information in these videos, and it's why it's so vitally important that you take advantage of it. All right, so we've talked about what assets to put into the trust. What about what assets to not put into the trust? Well, one of the things that I always share with people is that you need to understand beneficiary designations. I'm going to say that again, beneficiary designations. Now, what that means is you have certain accounts, maybe your retirement plans, your life insurance, your annuities, maybe different CDs, things like that, that when you first set those up, the financial institution or the plan administrator, whoever it may have been, the insurance professional that you were working with, when you established that, there was a lot of documentation that you had to fill out. One of the things you had to fill out was who is going to be the primary beneficiary on this account. Now, in many instances, people will put their spouse maybe as the primary beneficiary, but then they'll ask them for a backup such as the contingent beneficiary. Now, part of the reason for this is, let's say that you and your spouse are in a common accident. Ideally, that's not going to happen, but say you're in a car accident, you're in a plane crash, something like that, where you both pass away at the same time, and you've left as the beneficiary your spouse. Well, if you haven't named contingent beneficiaries, it's going to be subject to the potential intestate succession if it hasn't been transferred into a trust or something else. But what we have to make sure that we understand is the beneficiary designations serve a very important purpose. And one of the benefits of that, when it passes to the named beneficiary, it passes outside of probate. That's for retirement plans, also for insurance, for your annuities, all of these things. If they pass directly to the beneficiaries, you're avoiding probate for these assets. Because of that, I tell people you don't put those into the trust because they're essentially already held in trust pursuant to the beneficiary designations. So that's important information that you need to know about so you know not to worry about transferring these assets into your trust. Now, what you could do is name your trust as a contingent beneficiary if you want to make sure that that trust has certain restrictions on the use of those funds, especially if you have minor children or maybe children that you don't feel comfortable with receiving a lump sum of cash, this lump sum distribution all at once that perhaps they're ill-equipped to handle. This enables you to have additional restrictions on this, which gives you additional protection. And another thing we've got to take a look at is what about your business interest? And what I mean by that is maybe you've got your own business, maybe you operate an LLC for your rental real estate, which I touched on a little bit earlier, but I want to touch on it in a little more detail. Let's say that you operate a business and you have maybe a corporation, or you've got an S corporation, or you've got an LLC, or maybe you have ownership interest in a limited partnership. All of these things need to be transferred. Your ownership in these businesses needs to be transferred into your living trust in order for that to avoid probate, in order for that to be pursuant to the terms of your trust agreement, which will outline how it will be handled upon your death. These are important steps that you've got to take to make sure that these assets are covered. Now, whether it's an assignment of limited liability interest, an assignment of partnership interest, an assignment of business interest, because even if it's just maybe a side hustle that you're doing, you still want to think about this. So any of those business interests, sometimes people overlook this because they think, well, no, I already have my business set up in a legal entity. Well, that legal entity now needs to be assigned over into the name of your trust to make sure that it has the estate planning coverage. This is important information. And we've covered some really valuable strategies here, but for even more detail and more strategies, I've put together a special mini course that I call Enlightened Estate Planning. And I'll tell you, it's very special based on the strategies, but it's especially special for you because I'm offering it to you absolutely free of charge. All you have to do is click the link below and you'll gain access to the valuable information that I've outlined and included for you in the Enlightened Estate Planning course, and again, free of charge. All you have to do is click the link below to gain access. This is information that you need for yourself, for your family. Thanks so much for watching. I'm JJ Childers, and I look forward to seeing you in another video.